The 8th of October 2022. My camera is on this side here, so I have to look that way. This is 47p, and it's on the case 2419. It's called We Win Again. Now, if you go back, if you didn't see it already and you want to take time to look at it, first of all, for new subscribers, I'm a well-known environmental campaigner, struggling as best I can to preserve our Irish and indeed other environments. I am the Irish spokesman for the European Platform Against Wind Energy, and that we're aligned to the North American Platform Against Wind Energy also. But in Europe, we have member groups in all member states and other states as well, and we cooperate a lot to try and win. Now, what essentially is the law is that when the European Union was envisaged and when the various treaties were proposed, and Ireland, because of its constitution, had to vote for each treaty to join the EU at each stage, there was a treaty on the functioning of the European Union, and there was the Maastricht Treaty, and there was the Lisbon Treaty, and all of those promised proper environmental controls, a proper environment for the well-being of the people living in the European Union. And then they came along and they brought out the necessary directives to do that. And the way the directives were structured is there's an overarching directive, that's the Strategic Environmental Assessment Directive, SEA Directive 2001/42/EC. And Article 3.2 of that says that all public plans or programs for various industries must be assessed with public participation, and energy is included in that. Then there's the EIA directive, that's the local directive, that's for the particular application for the planning permission, and it runs alongside or on top of the Planning Act. So it's a bit technical, but just remember the EIA is the local directive, the Habitats Directive is local, but the SCA is the overarching plan and programme. So the Irish government decided in its wisdom that they would not do any SCA directive on wind, because they knew probably well, if they didn't, I knew it anyway, that when they do the assessment with engineering and expertise, they'd realise that the entire wind energy programme was a scam and can't work. There's 61,000 megawatts of industrial wind farms installed in Germany, and now there's panic. They're not worth twopence. They're not worth a wheelbarrow. In fact, they're using, in a calm day like today, the 8th of October, they're using all of the production of fossil fuel electricity in the Republic of Ireland to keep them going. They're consumers of electricity, and I have been claiming that for a long time, and people didn't want to believe me. But anyway, we are trying to get into the European Court of Justice, but my friend Pat Swords and I made various efforts, and we had European lawyers. They managed to keep us out, which they shouldn't have done, but they kept us out. Pat tried it in the Dublin court, and eventually they thwarted him there too. He couldn't get in. So essentially, we were challenging the National Renewable Energy Plan on the grounds that it was never assessed and that it should not go on. So that didn't work due to effective, what I believe is a form of corruption. They found little loopholes and all that, and they kept us out. So essentially, for me to challenge on anything, I need 40,000 with lawyers. Now, I have taken 3 High Court applications as a lay litigant on my own, and I won one of them. In the other one, the judge said that Bord Pleanála couldn't refuse the pylon application. That's the North-South Interconnector. And on the other one, it was very small. It was just, the judge didn't hear me. He was wrong. He said that it didn't need a notice on a public entrance, and that's the law says it does. But we're not going to go there. You win and lose. The problem with me is that if I go in as a lay litigant, I can bring it to the High Court. You could get any judge there. He may not have a clue about what you're talking about. But even if you do, you can appeal to the Supreme Court. Difficult enough as a farmer. It's about 18 days in Dublin, in normal times, or on the internet or that, to get your case into the High Court and plead it. And if you go to the Supreme Court, it's another 18. That's nearly 37 days to take a case. And really, I as a farmer have difficulty doing that. So I'd have to pick a specific, really good case. But the problem is if the Irish High Court or Supreme Court brings the case says they want to refer to Europe. Because I'm not a lawyer, I cannot refer to I cannot go and plead my case in the European Court of Justice. You have to have lawyers, and the minute you get lawyers, you need a barrister, a senior counsel, a junior counsel, and a solicitor. You need 40 grand up front. So how are we going to manage this? Now remember, normally the EU and the government would abide by the law. You don't normally have to take the government to court to claim the benefit of something that they have in the budget or whatever. But this is the case with energy. Now, the next thing is that back in 2019, there was a wind farm proposed, about I think it was a 5 turbine wind farm in an area of Belgium near the Flanders in Belgium. Now that was all right. It was the usual opposition and objections were made. But one of the things about wind farm planning is that there has to be guidelines. There has to be something to guide where to go. Otherwise, they could be put right on top of a house in the middle of Dublin City or in O'Connell Street, Dublin City. So one of the things they brought in the guidelines in Ireland was a 500-metre setback distance from dwellings. And that was similar to in Belgium. And then there's things on shadow flicker and all this sort of stuff, and regulations and all, how they're to be painted and a whole lot of things. No need to go into it here. But in Ireland, they brought out the 2006 wind energy guidelines, and in Belgium, they brought out the same, and they're nearly in every country. The EU must have told the governments of each member state, go and bring out a set of guidelines, and there's circulars or guidelines. In any event, this wind farm was applied for, and the citizens fought it. And when they lost, when it was granted permission, they went to court, in the local court, saying the wind energy guidelines were never assessed under the Article 3.2 of the directive. And the local court referred it to the European Court of Justice, the highest court, the Grand Chamber, and the Advocate General advises that court. And he wrote, Advocate General advised that they were never assessed, therefore they're illegal. So in his judgment, 2419, now you can search for judgments online, and in fairness, if I'm to put it right for you, it's C19, Curia 19. So C2419 is the case. It's from Belgium. And in that case, the court was asked to decide, could the guidelines be used? And the court said that if the guidelines are ones that would normally be taken account of, if they're from a government body, a council, or whatever else, then they are guidelines, they are part of the public planner programme. So what the governments in Belgium and all over was trying to say, they're only advisory, they're not compulsory, they're a guideline. But the European Court said if a circular or advice is such that the planning authority would likely to take account of it, then they are part of a public planner programme, and they got caught. The next thing, the court ruled that they're not assessed under Article 3.2 of the directive. And the next thing is what should be done, and they said that the planning application in Belgium must be annulled, must be quashed or annulled. Okay. Now, when it became obvious to the Belgian government that they were going to lose this, they asked a question. They put a question into the High Court, to the European Court of Justice. What about the existing wind farms that are granted under the 2006 guidelines in the various member states? And the European Court of Justice says they have to be annulled too. They're illegal, but you can keep them going for a short term if the electricity is urgently needed, which is not the case. So effectively, they said the existing ones have to be torn down. Now, I immediately got to work trying to get groups to include this on the statement of grounds. When you go into the court, you have to state your grounds, and you might have 6 or 7. You might say they're not properly described. You might say they didn't consider a particular frog or a particular species or a particular plant, the pearl mussel or something like that. So there's several different things. You might write them all down. You might say they don't have the right of the landowner to put up the pylons. You might say something like that. You might question the ownership of the land. There's lots of things you can put in. So there could be up to 25 to 30 grounds on your statement of grounds, and you might be trying to plead each one, and eventually a lot of them will be cast aside, and the court and yourself and others, all the parties will decide, well, we're only going to go in on 3. That's quite all right. That's the way it works. And then you have 3, and then it's coming before the court. Now, In one case in North Kildare, the group, I don't know, they might have done it anyway, but I gave them all the advice, and I advised them, and I'm not the only one advising on this, I advised them to include a ground on 2419. The fact that the guidelines, the Irish wind energy guidelines, which you'll find online, were never assessed with public participation. But they had other grounds, and Bord Pleanála withdrew on one of the other grounds. So we knew well what they were doing. They do not want to concede 2419 as a precedent. They want, so if they're stuck and they're coming before the court, they'll yield on something else. So that is that. The next thing was, there was another group in the Irish Midlands came to me, and we were ready to go. We were ready to actually go. We had our lawyers all backed up, and we had the cost of it with councils and all the rest. It was pushing near 40 grand. And there was only a small wind farm and a very small group, and they had limited resources, ordinary working people, and they didn't go ahead. I'd say they're probably sorry now, but that's the decision they had to make. So I was advising them and helping them on that. And the next thing was then Guagane Barra. It's a famous area down in Cork. I might have to get my computer here. And it's a lovely, beautiful area. I remember John B. Keane wrote something about Guagane Barra, and there's a hotel there. It's a very scenic spot. And of course, what do you know? Our lovely government and the wind weasels, these environmental criminals who put up these massive stuff, came along and they applied for planning permission. And of course, the local Cork County Council shut it down, but Bord Pleanála has been involved in all sorts of what do you call it, corruption. Some of them have had to resign. It's a mess there. I don't know who's doing there, who made this decision, but the whole thing is a corrupt mess. If there were decent people that accept that they shouldn't be granted these at all, but their way of looking at it is, if the government doesn't adopt the European law in 2419, it's not the law at all. So I'm just going to get the case here now. So I've got it here. It's in the MSN, I don't know what that is, but it was in the papers as well. I'll just see now, can I get me little kind of, it was the Irish Examiner, sorry, it was just hidden up at the top. The Irish Examiner. So here it is. On Bord Pleanála concedes legal battle over Guagane Barra wind farm. Now the way it works, when you go into the court, they can fight you or not, and they'll serve you with heaps of documents and all the rest. But then you eventually get round to a trial, and you try it then before the judge. Most judges are reasonably good. Some are good. Some don't know what they're talking about. And some are probably positively against you. So you have to go by that. But the thing about it is that I and a friend of mine who are on this made sure that the group in Guagane Barra were made aware of 2419. But according to the article here, the solicitor was Mr. Joe Noonan, and I'm not plugging anyone, but he's no one's fool, and I'm sure he knew without us. So, but we made sure as best we could that they were in. Now, just to rehash that again, because I had a pause there. In the case of the wind farm in North Kildare, the board conceded on another ground. They conceded 2419 was one of the grounds. The board did not want that, in our opinion, to be a precedent, and they conceded on the other grounds. In the case of one in another wind farm, a small 9 wind farm, a smaller one, 9, which is a lot, the group didn't go ahead, although we had all lined up. They just didn't go ahead. It was just too much money and too much pressure on ordinary people. And then Gaugane Barra came along, and they had Mr. Noonan, and they had a legal team, and we made sure they knew about that, and I think they did anyway, so we're not taking credit, but we made sure that the local people knew about this case, and they told us that they have it on the statement of grounds. And here's the news here now tomorrow, and a lot of people this morning, a lot of people mightn't understand how this legal system works. That was the reaction. I want to see what it says here now. And Bord Pleanála concedes, justice has been done, common sense prevails. Well, it is justice. It's not common sense on the part of the state. These rascals were going to destroy Gaugane Barra, just destroyed my community. Now, that was the reaction from campaigners opposed to the wind farm planning near scenic Gaugane Barra after the legal representative told them that Bord Pleanála conceded the legal battle over planning permission. Now, I can't speak for anyone, but I believe what's happened is they will not concede on 2419, they'll concede on something else. I'd love to go at them straight with 2419. Maybe I would yet. We'll see. They have now been told that Bord Pleanála will not continue its defence of a legal action brought by the group contesting the board's decision to overturn Cork County Council's planning permission. So this is Bord Pleanála. They conceded. They couldn't fight it. Why did they grant it if they couldn't fight it? You see, what's happening is those who are prepared to take them on and have the resources win, and those who don't lose. This is the most cruel thing the Irish state is doing. Now, a safe Gaugane Barra appeal raised €64,000 towards the group costs in fighting the legal case. So you see, money speaks, but they did raise it. Fair play to them. Campaign spokesman Niall Lucy, owner of the Gaugane Barra Hotel, said, "We are delighted with this great result. We feel that justice has been done, common sense prevails, and democracy restored to this situation." The group solicitor said Bord Pleanála has confirmed that it will not contest or oppose the case, and concedes to High Court to the making of an order quashing Bord Pleanála's decision to grant the planning permission to Windleaf Limited. That's the name of these, Windleaf. Yeah, they're calling after the Nissan Leaf. Another scam for the development of up to 7 wind turbines and associated works. Imagine the dig in there. 100 loads of concrete goes into the base. That's not to talk of the steel. Bord Pleanála was given, and then who owns the land? I know some of them who owns the land. There's no shame. They have no shame. Bord Pleanála has given the green light to the development in January after it had been refused planning permission by Cork County Council. And then it goes on like that. So they won, so fair play to them. Now the point I'm making is that there's 2 refused, other group couldn't go in, so it's very important. We'll be making sure there's another one coming up in the Irish Midlands, and they're well versed, and I think they'll have the money and all that. I tried to set up a national organisation with funding years ago, and I was thwarted. I don't know, is it possible, but we would have had, you see now, where the group wins, they get their costs. So that 64,000 that's set up will not be needed because the lawyers get their costs from Bord Pleanála. Bord Pleanála have a big chest to pay out all this taxpayers' money. So in the case of North Kildare, they don't have to pay their costs. In the case of Gaugane Barra, they don't have to pay their costs. And if we had a national organisation, we could use the cost, the money gathered, to fight the next one. So if there's they win, use that money, bring it forward to the next. You'd block every single one. Whether it's too late to do that or not, I don't know. That's what I had in mind over 12 years ago, and I was shot down by the people who were running the meeting, and that's what I say. I don't know what their motives were, but they didn't want to confront the government policy, whereas I do. Now, the thing about it is that the judgment goes further to say that the existing ones have to be taken down. Now, it's quite obvious to me, and you can judge it for yourself. The situation now is the government is caught between a rock and a hard place. If they bring in guidelines and they're not a way back, maybe at a metre from wind turbines, I'll go in and challenge them and tell them what the noise I'm suffering here and the shadow flicker at my farm. So I can give direct evidence now of what the effect of them is. And I'd have to probably win, and others do the same. So they're going to have to make the distance a way out, maybe to 900 kilometres or 900 metres or something like that from a turbine, and that'll shut off most of the country. Moreover, if they do set the setback distances at 800 yards, we'll say 900 kilometres, or a kilometre. No. The distance is 500 metres from the nearest house to a turbine. Right? If they bring out new guidelines and leave it at 500, I'm going to challenge them in the court because I can prove that that the noise is too severe, and many others the same. So they're going to have a scientific report. They're going to have all kinds of people there. There's going to have to be public participation, and they're going to be in trouble. The other point, if they decide to leave it at a kilometre, we'll say, this is a bit wobbly, this thing here, this phone. So we'll say they decide to make it a kilometre instead of 500. Well, then that's proof that the existing ones are too close. And when I go in to challenge the existing ones for nuisance and to shut them down under 2419, I have evidence that the government has already agreed that 500 metres is too short. Do you get my point? So they're caught between a rock and a hard place, and all we have to do now is try and help groups everywhere to get their ducks lined up and go in on 2419. It's one I might take on myself because it wouldn't necessarily have to go to the European Court of Justice. I cannot see the Irish Supreme Court uh, ruling against this judgment. You'd have to read it. There's three parts. One, the wind farm in Belgium has to be annulled. No wind farm there. Two, if there is guidelines and those guidelines are ones that the planning authority would normally take heed of, then they are law, and they have to be assessed under Article 3.2 of the directive. And then the third one is if they're already built, they have to come down, but they can stay going for a few months until you get some replacement, which doesn't apply in the case of wind energy. So that's the law there. So we'll be working on that. Now it's 20 minutes aside by that. I'll do another one about another case we're taking as we fight these in the courts and the way my mind works. And yeah, a lot of people, Irish people are soft, and many people say, actually, we'll fight it a bit. And my attitude is, not only do we have to fight these wind turbines, we have to bring accountability to the corrupt politicians, lawmakers, staff, and even if the courts are found to be corrupt or to make a corrupt decision, all of this must be brought to a public inquiry, open legal inquiry, where we can examine all the parts and bring them to justice and make them accountable. Barry Cowan has already do this. So if we begin to win, or I begin to win, and I have my health, I'm not stopping and saying that's the end of it. We'll pursue them down. We'll pursue them down onto anyone who made a submission or a falsehood or put in any document or anything that we can get. I will keep investigating them and reporting them to the Gardaí and all till we try and get them cornered, if possible with criminal offences, and even fined or jailed or with everything else. That'll put the wits up them, and that's the way it's going. Anyway, the main point is 2419 has not been conceded in the Irish court because the lawyers for the board will not let it be contested, because they don't want it to be made a precedent. It seems to me to be sealed. I discussed it with some barristers and they agree there's no way out of 2419. I would urge you to take a read at it, and particularly the black writing in the bottom, and give me a thumbs up or a thumbs down. We'll see you back for something else. We keep fighting, and then we enjoy the fighting. I don't do this out of craving. I'm not saying I want sympathy. I'm saying I enjoy this. This is the best sport I ever got in, chasing our corrupt politicians. Thank you very much. We'll see you back for something soon. Give me a thumbs up, a thumbs down.